Hi, I'm Bill Andersen, and I am going to be talking a little bit today about the latest Supreme Court term, which has been quite a dramatic term in terms of the major doctrines that have been announced and the major cases that have been decided. There's been an enormous amount of writing and commentary that I'm sure the listeners have all read and heard ad infinitum, and I think it's probably not necessary for me to have this talk because you all know all of the ins and outs of the doctrine and all the ins and outs of the policies. But I'm going to go ahead anyway and give you a very brief account. Now, the court had received its usual thousands and thousands of petitions that were appealed to it, and it picked out of the huge mass of possibilities about 50 or 60 cases that it actually heard and decided. And I'm going to limit my talk today to 4 cases because they're complicated and they're important, but we'll only be talking about 4 cases, one involving guns, one involving religion, one involving abortion, and one involving what critics call the administrative state, a major decision there. So we'll be talking about things of that sort. And I will be very briefly talking about the cases in doctrinal terms. I won't get into too many weeds because some of these cases are very complicated, and you don't need to get to the really nitty-gritty details to understand the importance of the case. Okay, let's start with a hypothetical. This is the way we teach law students, incidentally. We give them a hypothetical, then ask them what they do, and we discuss it. Here's an interesting hypothetical. You're a school district, and you have in one of the schools in your district a high school football coach who has begun to lecture to his players in the locker room on the virtues of Christianity. Well, you heard about that, and you're a public school, and you know that's illegal. So you call up the coach and say, please stop doing that. And he stops doing that. But then he starts showing up after each game. When the game is over, he goes out to the 50-yard line, kneels down and prays. Or it's a short prayer, about 30 seconds. And after a few of these things happen, some students start to go out and join him. And then soon some students from the opposing team join. And then some parents from both sides begin to go out in the field and join. And it gets to be quite a crowd. Again, you're fearful as a school district that this violates the church and state business. You know, you can't conduct prayers in churches or in schools. So this looks to them very much like a prayer in school. So you ask the coach to stop, and you offer the coach a private place to conduct his religious practices, a room off the field where he can go pray to his heart's content, out of the sight of the crowd and the players and all that stuff. He rejects this invitation and insists on going back out on the 50-yard line after each game. Indeed, he puts a note on Facebook telling the world the dates when he's going to be doing this. And as you can imagine, considerable crowds start to arrive, and the crowds get unruly. There are 400 or 500 people. They're pushing and shoving. Some band members get knocked down. It's not a comfortable sight. So the question to you in this hypothetical is, you're the school district, what do? You've tried settlement, you've tried offering him another place to go, but that hasn't worked. He continues to do this, and the crowds continue to get unruly and large. And so you've got something to do. Well, what this school district did, having settlement failing, they simply failed to renew his contract. He's on a 1-year contract. He's a coach of the junior varsity team, not the varsity team, and they did not renew his contract. And so he sued, and the lower courts said he could not win that case because the school is not permitted to endorse religion in that way. And so the lower courts upheld the school in getting rid of this coach. He appealed, and of course his appeal wound several years through the court system, winds up at the Supreme Court this term, and the Supreme Court reversed the lower courts and upheld the coach in his desire to pray after these games. Now, the doctrine of this case, this is from Bremerton, it's a local case. The doctrine is that, we have the Establishment Clause in the First Amendment that Congress shall make no law respecting the establishment of religion. And we have the Free Exercise Clause in that same sentence that says Congress shall not interfere with anyone's free exercise of their religion. And we've talked about that before in some of these conversations we've had. And you remember that there's a special difficulty, never very usefully resolved by the analysis, about what happens when these two clauses conflict. And it is a problem that arises in this case, because permitting the coach to pray violates the Establishment Clause, seems to show that the school has endorsed religion and it is coercing students. And that seems to be a violation. On the other hand, if you prohibit the coach from praying, that seems to infringe his right to the free exercise of his religion. So you've got a case in which you have two constitutional provisions that conflict. And that's always a problem for the court. The court reverses 6-3, and we're used now to that particular allocation of votes. We have 6 relatively conservative members, 6 relatively liberal members, and they split according to their views, 6-3 in this case. And the argument made by the majority here is that this violates the Free Exercise Clause because he's entitled to pray if he wants to pray, and this ruling by the school district infringes his right to pray. What about the Establishment Clause? Well, the court says that cannot be used as an excuse to interfere with someone's exercise. So you get a sense of this opinion that when these two clauses conflict, as they do in a case like this, the Free Exercise Clause is going to trump the Establishment Clause. And we're not sure where that's going, what the limits are, but that seems to be a very correct summary of what the court did. So the question is why the court goes on to talk about the Establishment Clause and says, if you look at history and tradition, and that's a phrase we're going to hear a lot of this morning, if you look to history and tradition, not so much technical doctrine, you discover that you have to limit the meaning of these constitutional terms to the kinds of meanings that the framers would have understood in their time. And if you look at it in that perspective, says the court, the framers would have surely understood the need to keep government from endorsing a religion or from coercing students. But neither of those conditions is present in this case. Now, this is a very interesting thing because as you might have, if you've read about the case, you might have said, well, wait a minute, this was an endorsement and it was coercing students, but the court didn't see the facts that way. There's no endorsement, the court said, because this was a private personal act, not implying government approval. Well, the dissent said, wait a minute, this guy's a well-known school official. He's acting on school property during an important official school event. And the photographs, which are printed in the dissent, and so we don't get photographs in dissenting opinions very much, but here are some, if you look at them in the dissent in this case, showing hundreds of people, huge crowds. The coach, they're all on their knees. The coach is standing in the middle with his helmet raised high, like Spartacus, I guess. But it hardly seems a private, personal event if you look at it that way. So endorsement is something that seems to me was obvious here. This clearly was regarded as a school event, a school endorsement. But the court said no, it was simply a private, personal act. Nor, said the court, was there any coercion of students because the coach did not require his students to join him in prayer. Fact is, some of them asked him if they could, and his quotation is, quote, "It's a free country, do as you like," close quote. And of course, the court says that means they weren't obliged to engage in this activity and could come or not as they chose. So there was no coercion. Now, if you know anything about football teams and coaches and the relationship between coaches and players and the importance of staying on the right side of the coach to get playing time and so on, you'll know that there was obviously some coercion here by usual standards, but the court didn't think so. So the conclusion the court says is that the free exercise clause trumps the establishment clause, and establishment is going to be hard to establish anyway, even if you give it some weight, because if the court is this generous in interpreting things like sponsorship, endorsement, and coercion, there's not going to be much that the school is going to be able to do. So we have, I think, another example in the case. We've talked about several of them in the last few years, but the court is slowly and slowly moving in a direction of adding more weight to the religious element in these balances and less weight to other things. And the result is being that we're going to probably find the government's ability to restrict religious practices in schools and other public places may be reduced as we move on into history. And I hope we don't get back to the required Bible reading and required prayer days. I hope we're beyond those for good, but we're heading back in that direction if I read this case directly. There was another case about religion in the same opinion, a main case involving private schools, and can the state subsidize private schools without also having an obligation to subsidize religious schools? And the court in that case, a little unusual arrangement there, but again, it's another indication by the same majority that the state is going to be less and less able to restrict support to religious schools and activities than they might have been under prior doctrine. So we see religion on the rise in the balancing that the court inevitably has to do in these cases. Well, let's give you another hypothetical. Suppose a state wants to license handguns before it allows owners to carry them around on the street. And the state wants to be sure that the owner of the gun has no convictions for felonies, no mental health issues, no records of domestic abuse, etc. So they have a series of criteria that are used in deciding whether to issue a license. And they add to that list of objective criteria about records and so on, because they want to have maximum safety. They want to limit licenses to those people who have special needs for carrying guns. So the statute says, in addition to establishing all these records, that you have no history of mental health, criminal convictions, et cetera, you also have to be a person who has a special need to carry a gun, not just the general feeling of the citizenry that you can, you feel more comfortable with a gun. That's not enough. You have to have some special need. And historically, that's meant in these states. You have to carry in your business, you have to carry a lot of cash, or you receive specific threats from individuals and so on. And that statute was attacked. And the question is, what do you do about the state's desire to have that sort of a test before it licenses people to carry guns? So you recall that in 2008, the Heller case, the Second Amendment case, established that individuals have a right to have a gun in their home for self-defense. That's a constitutional right. So the question is, suppose, does the gun owner have a right to carry a gun outside the home for self-defense? And if so, what kind of restrictions can the state put on that, expressing that interest? The statute in this case, the special needs description in the statute said the applicant must have a special need for the gun, quote, distinguishable from that of the general community, close quote. So you had to have some special need of the kind we've suggested before. And a number of states have these kind of statutes, maybe a half a dozen. Most other states have a licensing provision like this, as Washington does, that does not have a statute that does not have that special needs requirement, but still has a list of objective criteria about your criminal record, your mental health, and so on. So when these cases about these restrictions came before the courts, the lower courts, with using the usual constitutional theory of balancing the burden of the citizen against the public need, tended to uphold these statutes on the theory that the burden on the citizen was not great and the the public need for safety was great. Well, the Supreme Court rejects some of those lower court decisions, again, 6-3, and they don't use this traditional constitutional law balance theory at all. They go back to history and tradition, as we saw in the prior discussion. They go through an elaborate history to see if there's any historical warrant for this kind of regulation. And we're talking now about regulations which require a special need to get a gun permit. And they found no historical warrant for this. Now, this was an extraordinary historical study, and if you read these pages and pages and pages of historical stuff in the majority and in the dissent, you'll discover that what's going on is pretty much what historians call cherry picking. You can go back through the history and discover all kinds of things and pick out this and pick out that and come up with some solutions. So it's not, history and tradition is not an easy matter to deal with. But this court finds no historical warrant for this kind of a rule, and so says it's not permissible. So the Second Amendment right established in Heller to have a gun in your home for self-defense has now been extended to having a gun outside your home for self-defense. And all the same restrictions in the Heller case about states' ability to limit those rights, to keep them out of schools, and keep them out of courtrooms, keep them out of other kinds of places, and their ability to restrict licensing to people without criminal records, etc. All those things are still there. And the language in the Heller case itself was quite generous in that respect. But the court says those same restrictions are going to be here. So we now have a constitutional right to carry a gun outside the home, subject only to limited state restrictions for criminal records, mental health, and so on. The dissent, of course, gave us the usual parade of horribles. There are 4 million guns in the United States. There are 40,000 deaths annually. But that's where we are. Now, it's very clear, and I want you to understand this. The case sounds pretty bad, like everybody's going to get a gun. But the objective standards in New York, where this restriction was imposed, included things like background checks, fingerprinting, no convictions for felonies, domestic abuse problems, mental health is going to be looked at, training requirements sometimes, and the license itself can be limited to special places like schools, courthouses, and so on. And in addition to that list of things which are okay, Roberts and Kavanaugh had a concurring opinion, say they'd go a little further even than Thomas's opinion there. They would like to be sure that states have freedom to limit the issuance of license for these carry licenses a little further than Thomas would have been willing to go, but still not reaching a subjective place where some official has to decide where you have a special need. If the criteria can be objective, then I think Roberts and Kavanaugh will go along with those. What that means to Thomas is that if he wants to push this doctrine further, he's not going to have the 2 votes that he needs. Now, as I say, Washington has one of these statutes, and it limits, has some objective criteria about felonies and mental health. It has some places where guns cannot be taken, including bars, for example, and it authorizes cities to ban guns at special places like sports stadiums and so on. Just a footnote here to remind you of how complicated these questions can be. There were some women's groups and gay and lesbian groups that attacked the New York law because it prevented them from carrying weapons for their own self-defense. They don't have special needs like somebody carrying a satchel full of money. The fact that they are targeted groups these days and possibly in grave danger in many situations, they still could not have gotten a license from New York under the special needs limit. And so they didn't like the New York law. So you got it's unlikely that those groups would find Justice Thomas protecting their interests, but he did in this case. And that's just an example of the kinds of complexity that these cases produce. Now, how far can states go? We don't know. But I tell you this, that New York, right after the opinion came down, immediately adopted a new law that includes in the objective criteria 16 hours of training, 2 hours of range practice, an in-person interview, written exams, all this in addition to the objective criteria about felony records and mental health and so on, fingerprinting and all the rest of it. And it also lists some special places where the license does not permit you to carry a gun. And the special places include public venues like Times Square. I'm sure this will be tested and we'll have to see what the courts do with it, but it shows you that some states can be very serious about this and feel it very deeply. And so that's where New York is now. On the general gun question, there's not much that we can say. Congress did pass a law the other day, bless their hearts for doing something, which increased incentives for state red flag laws and extended some remedies for domestic abuse and extended background checks for 18 to 21-year-olds. But we're not going to get any major legislation out of Congress to control the use of guns. And so we're left with what the states can manage to squeak by through this new court authority. Here's another hypothetical. Suppose you're the administrator of a federal agency, say the Environmental Protection Agency, and you want to adopt more stringent standards for reducing greenhouse gases in the coal industry. Now, you've had regulations before of the coal industry, and they've all focused on requiring the companies to burn their coal more cleanly with various kinds of techniques and processes and equipment. But that's not getting you the results you want. And so your technical people, of which you have floorfuls of technical people, they note that if you could ask the coal companies to begin to somehow or other, and then how they do it is complicated. You would have to talk about it later, but the idea is to get the coal companies to begin selling electricity, which is what they do with their coal production, to sell some of that electricity, which is produced by using natural gas or wind or solar, which would require the companies to invest in these industries or contract with these industries. So they reduce the use of coal in the production of electricity, but increase the use of natural gas, wind, and solar. And your technical people say, we can do that, and the companies can do that. Why don't you require them to do that? What does the statute say? Well, the statute says the APA can regulate the coal industry and can adopt, and I'm quoting now, the best system of emission reduction, close quote, that the agency can find, the best system of emission reduction. So then, well, we think this is the best system of emission reduction, so we're going to go ahead and have a rule requiring the coal companies to get involved in the wind and solar and natural gas industries so that they can reduce the use of coal for the generation of electricity. Now, just to think about the nature of this process, as you will know from high school civics, we all took that, didn't we? Administrative agencies like the APA are agents of the legislature. They're created by legislative act. Their powers all come from legislative statutes. And while there's some executive branch influence on the agencies because the head people are appointed by the president, nevertheless, all of the powers exercised by the agencies come from statutes which Congress has drafted, and any rule not within the statute will be declared invalid by the courts. And I can assure you from personal experience that Congress pays a lot of attention to how these agencies are conducting themselves, how these agencies are exercising the power that Congress has given them. And so day-to-day action within the agency is a lot of phone calls and letters, and these days texts and emails and what have you from Congress and congressional staff on this rule and that rule that the agency is thinking about. So it's a highly rich interchange between the legislature. So now when a court gets a case in which someone claims, as the coal industry did here, that this regulation is outside the authority granted to it by the legislature, how does the court approach that question? The court will know that there have been a floor full of lawyers within the agency, expert lawyers, experienced lawyers, knowledgeable lawyers, who've ruled on this proposal, this rule, and said, we think it's within the authority. We've interpreted the statute and we think this is within the agency's authority and it will survive judicial attack. So the court knows it's not the first set of people to look at this legal question. And the question is, what attitude should the court have when it reaches one of these questions? Should it accept the agency's judgment about the breadth of the statute? Because the agency, after all, is the expert on this sort of thing. And the agency's had clearly a broad input from the public. These regulations have to be published, and volumes and volumes of public comment is received as a result of that publication of the draft. And the agency has to consider all of that before it moves ahead. So the agency's judgment is not only the judgment of a lot of lawyers who have a lot of experience in the area, but a lot of technical people who know what works and what doesn't work, and a broad view of the public that comes from all this comment process. So a court might say, let's just accept the agency judgment. The legal question here is, it has been well considered by people who know what needs to be known. Or the court could say, well, we're more expert than the agencies on legal questions. Yeah, they're lawyers, but we're independent courts, and we should make up our own mind about the breadth of the statute. Well, that attitude, what the judicial approach is, has varied over time. In the early 1930s, the courts were very stingy and very disrespectful of agency interpretations, and struck down a lot of statutes, a lot of activities that seemed to be in the view of the court beyond the statutory grant. In the 1937 and beyond, there was an attitude change in the court, and the courts have been since then pretty liberal in accepting the agency's judgment. And if the statute is ambiguous, the courts have sort of adopted the notion if the statute is ambiguous, they're going to accept the agency's interpretation if it seems reasonable. And that left the court plenty of room to move because the court gets to decide what's reasonable. But it, by and large, led to a significant amount of deference by courts to agencies' legal judgments about the breadth of one of these statutes. Well, the court in this case set aside some lower court opinions of the sort I just described and said, well, we're going to use a different standard now. If the question that the agency rule affects is a, quote, major question, close quote, and the statute is ambiguous, as they almost always are, incidentally, the court should deny the power to the agency and send it back to the agency to rethink. Because when the rule has to do with a major question, the court says, we're not really sure that Congress intended that unless Congress was a little more specific than it was. And since this is highly impactful, this kind of major question, we don't think it's safe to let the agency's judgment about what the statute means stand. And now we have something called the major question doctrine. And it just simply says when the court decides it's a major question, because it's novel or because its impact is great, it's going to take pretty specific congressional authorization before the court's going to permit an agency to act on it that way. And in this case, the rule was novel. Switching industries had not been tried before, and it was highly impactful. It was, the court cites billions of dollars in costs to the coal industry and billions of dollars in costs to the economy and prices of coal, prices of electricity, jobs, etc. And the court said, that's a very impactful thing. That's clearly a major question. And we think before we're safe in having that rule within the statute, we'd like the statute to be a little more clear. So the court sets aside the rule. Now, you will know, thinking of some of these words, well, when is the statute ambiguous? And as I say, it almost always is. And sometimes it's intentionally ambiguous because that's the only way Congress can get a coalition to support the statute. And the thought is that if you leave it ambiguous, then later on in some other venue, some other place, you can work out the details. But by and large, statutes are frequently ambiguous. And this phrase that was stated here about the best possible thing, that doesn't tell you very much. So you say, well, that's not a problem because the agency just has to go back to Congress and get a little clearer statute. Well, that's fine. But think for a minute about going back to the Senate and asking Senator Manchin to support a bill that will add significant cost to the coal industry. Fact is, the agency will not be able to go back to Congress and get anything helpful because of the difficulty of getting some kinds of issues through Congress at certain times. So I think this is a matter that could be a very important opinion. And notice, we don't know how far it's going, how generous the court's going to be with its interpretation of what is a major question, but I can assure you that this doesn't apply just to the Environmental Protection Agency. It applies to every single administrative agency regulating everything. And if the court is now going to say that the agency has to follow precise guidelines laid down by the statute in anything the court thinks is a, quote, major question, close quote, we may have a significant reduction in the flexibility of these agencies to act. And that's something that I think below the radar in a lot of the newspaper accounts, but that could be a major game changer as we see how it works out. Well, saving the best for last, the fourth case I want to talk about is the abortion question. And I know you've all heard a lot of stuff about that. And I think the case arose in Mississippi. And Mississippi decided that the Roe against Wade, the 1972 opinion of the court, which created a right to abortion, said that the right to abortion only extends to a certain time period. Roe against Wade was one of these, ultimately a compromise, an awkward compromise as it happened. But the case basically realized that the public was divided on the question of abortion, and yet we needed a national rule so that we could know what the rule was around the country. And it's sort of said some abortions are okay and some are not. It's a typical compromise. The line drawn between what's permitted and what's not permitted was a timeline. And they said sort of 24 weeks. The state could prohibit abortion after 24 weeks, but it could not prohibit abortion before 24 weeks. Now, why 24 weeks? Well, there's been a lot of conversation about that, a lot of discussion of where that number came from and what it really means. You can be sure that the notion is that the objection to abortion is that there's a human being involved. And so there was some possibility that if the court said before 24 weeks, the fetus could not survive being outside the womb, but after that time it could. And so stopping the development of the embryo after that time looked a little more, felt a little more like taking a human life, because there was something which could exist outside the womb at that point. That's one of the reasons for the 24-week rule, and there are lots of others. We talk about quickening, we talk about heartbeat, we talk about when the embryo begins to be conscious, when it can feel pain, and so on. There are all kinds of conversations about that. But the fact is that there's no scientific notion, no way of proving when life begins. Science can tell us about when certain cells move in certain ways and begin to do certain things. But the question of whether life begins or not is not really a scientific question that can be answered. And so there are religious views that can answer the question for you, but unfortunately they're not consistent. And that's one of the difficulties with working with the abortion issue. If I have millions of Christians who believe that life begins at conception, I have also millions of Jewish people who believe that life begins when the embryo comes out of the uterus and takes its first breath. Now, how do I deal with the fact that that many people on both sides of that issue, and the answer is quite different. So it's going to be a hard question for a court, I can tell you that, and not the kind of question that courts are very good at. They don't have the tools, they don't have the background, they don't have the time to reflect, and the ability to study and so on that others might have. So it's always going to be a difficult thing for a court. And it's also an issue on which very strong public opinion exists. And the public is about evenly divided on abortion, depending on when you count and how you count and who you count, how the question is framed and so on. But there's major numbers of people on both sides of that issue. So that's another thing that courts are going to have to deal with. And the issue itself, as I said, is not a scientific issue about which you might discuss compromise. And we're talking about regulating the coal industry. We can always talk about different kinds of measures. How long should we regulate? How deeply should we regulate? How, so on, and how broadly we should regulate. All those things are subject to discussion and compromise. But with respect to abortion, you don't have that kind of a system. The woman either has the abortion or she does not. The fetus is either alive or it's not, and there's no way to compromise on that side of issue. And that again makes it a difficult thing for courts to deal with in any way. Now, the long history of abortion and law, when it goes back to the beginning of time, I think, it's a very convoluted history. Abortion has been approved, it's been disapproved, it's been criminalized, it's been welcomed, it's been approved by the medical profession and disapproved by the medical profession and so on. And all countries have struggled with this. And it is something that is simply very difficult to work out. Again, a bad idea to give a court to decide. In the United States, about 800,000 abortions a year happen. No, about 800,000 a year abortions are reported. Nobody really knows how many happen because an awful lot of abortion takes place outside of recorded institutions and so on. The rate of abortion has been falling steadily. And I will tell you that if you thought that Roe against Wade, which provided a constitutional basis for abortion, would have increased the rate of abortion, it didn't. In fact, all the abortion rates have continued to decline even after Roe. So, and why is that? Well, we assume it's a matter of education, a matter of contraception, a matter of various things of that sort. It doesn't have much to do with abortion law. But the fact is, abortions are, the rate is going down. There's still a lot of them. And it's medically, abortion, early abortion before 20 weeks or so, is very safe. And I think the doctors will tell you that it's much safer than childbirth. And so abortions are safe procedures. With Roe against Wade in 1972, we have a holding, again, an awkward compromise, a divided court, 7-2, but an awkward compromise, as I say, permitting some abortions and not others by this dividing line of 23 weeks, whatever it was, dressed up in various kinds of notions about viability or consciousness or heartbeats or whatever. Doctrinally, the constitutional basis for Roe was simply, since there's nothing in the Constitution about abortions, what the court did there was say the Due Process Clause, which applies to the states after the 14th Amendment in 1868, rules out government intrusion into certain highly personal, highly private aspects of life. That in a civilized society, an ordered society, a society where liberty is championed, various things like marital intimacy, procreation, reproductive matters, bodily autonomy, these kinds of things should not be interfered with by government. If they are interfered with by government, you lose a lot of the dignity of being an individual. And that's not what a good system ought to be. And the court put that into a right of privacy that does not exist in textual form in the Due Process Clause. But the court said there should be such a right, and it should be a matter of due process. So that particular ruling led to some other personal intimacy matters, which were protected by the 14th Amendment, including same-sex marriage, getting rid of the criminalization of homosexual behavior, the availability of contraception, and other kinds of things, which the court has done up until now under this right to privacy. Now, there were a lot of criticisms of Roe because all compromises disappoint half the people who were working with them. And so there are a lot of states where abortion was thought to be a bad thing, began to adopt restrictions on abortion. And so they had restrictions on providers, what kind of medical people you had to have for abortions. They have restrictions on waiting periods, how long you had to wait to get an abortion. They had requirements of counseling and parental approval for minors. They had standards for the facilities, what kind of equipment you had to have in abortion clinics. Literally hundreds of such restrictions at the state level, all ostensibly aimed at the safety of the patient, but more probably intended to reduce the number of abortions. So this gave us an extraordinarily complicated set of rules around the country, and it was not a pretty sight. But Roe had one very important advantage. Being a national rule, it had the quality of providing that all women, wherever they live, could get access to safe abortions. And the fact that some women couldn't travel to other states if it were a state-by-state matter, some women who had less economic means or were more enmeshed in their own families or their own jobs or their own situation and couldn't travel, that discrimination against those lower resourced women was not present because there was a national rule. Whatever you thought about abortion, any woman who wanted one could get a safe abortion in her own state. One of the things that meant was that if she couldn't get it within her own state because Roe was overruled, then what would she do? If she couldn't manage her life and her resources to travel elsewhere for it, that doesn't mean she wouldn't get an abortion. That just means she would not get a supervised, safe abortion. There are plenty of opportunities for abortion outside the clinics, and those can be widely used, and for all we know are used a lot, and that kind of abortion would be not as safe as the kind that are supervised, but could be unsafe. So Roe's natural advantages too, it avoided economic discrimination against women who didn't have the resources to travel, and it also did not have any inducement to encourage people to use unsupervised abortions. And so Roe had those advantages. Its disadvantages, a fairly thin constitutional basis text-wise, and what happened recently is that politicians have, bless their hearts, have discovered the electoral value of the anti-abortion argument. Candidates would run for state legislature saying, vote for me and I'll impose restrictions on abortion just as far as the Supreme Court will let me go. And so we'll reduce the number of abortions that way. And presidential candidates would say, vote for me and I will appoint judges who will overrule Roe against Wade. And as you see, as you know, a lot of that actually happened. And the result, particularly on the presidential level, with some chicanery by some political managers of the appointment process in the Senate, some surprising vacancies, some unexpected deaths. We now wind up with 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who are all pretty staunch conservatives. Particularly, they're all raised Catholic, pretty typically anti-abortion. Now, Kavanaugh and Gorsuch was raised Catholic, but is now an Episcopalian. One of them, I can't remember who it was, but they all began as Catholics, and the others are staunch Catholics. Barrett being a kind of poster child of what women can do in that church, and she's quite an impressive woman. So when the case came up to the court this time, it was different from the case that decided Roe against Wade. we have 6 people who seem to be leaning opposed in opposition to abortion, and 3 in favor of permitting Roe against Wade to stand. And you know what happens. Roe against Wade is overruled, and the doctrine that the court uses, you're probably used to hearing that this morning or this evening. Since the right to abortion is not mentioned in the Constitution, as guns are mentioned, to find it there, you've got to find something in the history and tradition of the country which gives some warrant to the idea that there should be protection for women who need abortion. And again, a long historical analysis by the majority, and another one by the dissent coming out the other way. And again, it's cherry picking. Disciplined or historians, credentialed historians call this law office history or judicial chambers history. It's not really good history because cherry picking is always easy in something this long and complicated. It's a very complicated haystack, and the elusive needle is not going to be easy to identify. So one of the things you get out of this emphasis on history and tradition in the court this term is that there'd be a lot of discretion on the part of the courts to decide what that history shows, where that needle is in that haystack. And that, while that may be inconsistent with the notion that judges should behave with restraint, particularly among those originalists who like this kind of stuff, the fact is it's an invitation to judicial creativity when the standards are so vague and the evidence so unclear. The other thing the court says in Dobbs is that stare decisis won't help Roe, because stare decisis only works if the opinion was reasoned properly in the first place, and this one was not, according to the majority. It was egregiously wrong, and so we don't have to worry about stare decisis. Ordinarily, we do follow cases, but not when they're as bad as this one. And so Roe is specifically overruled. There is no constitutional right to abortion under the Constitution. And the question of the possibility of abortion is now returned to the states for individual decision. So states can prohibit abortion if they like. They can permit it if they like. The federal government will not, the federal courts will not intervene. This raises a whole host of questions that you've read about, I'm sure, many times. One that I find particularly difficult is whether or not this opinion will lead to retreating on some of the earlier right to privacy interests that have been protected by the court in the last few years. The same-sex marriage business, the non-criminalization of homosexual behavior, contraception, and those other kind of things, which also were rooted in the right to privacy that the current court says does not exist. Now, Justice Alito, in his opinion, used very strong language to say, no, don't worry about that, because abortion is different. It involves the termination of life, and none of those other things do. So this case will be no authority, he says, for overruling those cases. And if you trust Justice Alito to mean what he says, then you can sleep nights on that one. Now, what can be done if there's no chance of having a reversal in the Supreme Court? There's state legislative action, of course, and that has to be now where the yes or no on abortion has to be decided. Federal legislative action, there's a movement, of course, to codify Roe and make there be a federal right to abortion. That's unlikely given the way the political world is now arranged, and I think those in favor of that simply don't have the votes in Congress. There could be some federal executive action protecting access to medication, access to travel, access to emergency medical care, public education. And the Department of Justice has even said it's going to convene an army of pro bono lawyers to help patients and providers with these questions. That seems to me like a lovely idea. Beyond that, all we can do, there's a woman who's a professor at NYU who has consulted with the White House on this stuff. Melissa Murray is her name. And she was asked, what can we do with this case? And she said, you can try all those executive actions and try all that legislative action. You can lobby your state legislature, but she said, in the end, she said, you can cry or you can vote. And I think that's kind of where most people are. A final personal comment on this abortion thing, and I don't want to bother you with my own views, but it seems to me when you have an issue that divides people in a major way, like this one does, it's simply not a good thing to have it decided by courts. There's simply no way a court can deal with a compromise. And if it doesn't permit a compromise, then you simply have a situation in which the rule bangs back and forth between this view and that view, depending on how the political chips fall in a particular jurisdiction in a particular year. So if you're going to have if you have a decision that turns not on scientific evidence, but on religious or ethical or other kinds of considerations that are not subjected to any kind of scientific evaluation, then it seems to me it's better to just concede that there's no that our inability to agree doesn't produce any unintended collateral damage. And I think there is some collateral damage here. As we said earlier, abortion restrictions don't reduce the number of abortions, they just reduce the number of safe abortions. And that's an intolerable situation for a civilization to live with. And it also, the understanding now does involve economic discrimination against many women who don't have the resources to solve the problem by traveling. Those kinds of things seem to me unacceptable, and I think maybe the best we can do is the Roe compromise. As bad as it is, as awkward as it is, it nevertheless avoids some of that collateral damage. So my own personal view is that this is a matter that ought to be left out of the courts. Religious people and ethicists who have views on continue to persuade women that their ethical and religious concerns are correct. And I have no problem about anybody believing any of that stuff if that's what they like. But bringing the government to bear in the question and forcing women into situations because the government decides that this is what ought to happen, I think is not a good idea. And indeed, it's the pole star behind the separation of church and state. Founders knew the indescribably bloody examples of allowing religion and government to get tangled up in the 16th and 17th century. You just can't believe the ferocity of those wars and the number of human beings who were butchered in those wars. And I think that having religion and politics tangled up runs that risk. And it's still going on around the world, as you know. So my sense is that there's plenty of constitutional common sense to let this happen under a decision like Roe. And finally, a word, I don't want to offend anybody, but I can tell you this, I have a strong sense that this abortion issue, all the conversations, all the writing, all the discussions, or most of it anyway, has a very distinctly male quality to it. When somebody says to me, well, if a woman is pregnant and she didn't intend to become pregnant, then she can go ahead and have the baby. And then if she doesn't want to or can't raise the baby, then she can just send it along for adoption or foster care or something of that sort. That's, I think, a view that simply overlooks the impact of pregnancy on the life of a woman. Not only physically, months and months of pain and discomfort, but emotionally. The evolution has built a series of deep emotional currents that run in a pregnant woman to prepare the body for birth and nurture. And all those things are happening in the woman's body. And a disruption in life also can have effects on the woman's career, her family planning, and everything else. And for a man to say, well, she should just go ahead and have the baby and then give it up for adoption if she doesn't want it, is a little bit like saying it's like a decision whether to pick up the dry cleaning this afternoon. It's a much more consequential matter than that. And I think us males, instead of being as arrogant as we are, ought to give that some thought. In this male arrogance that I see, there is an unmistakable sense, nobody says it, very much, but it's unmistakable that the female is to blame for this unexpected event. And thus, the female is appropriately the sole bearer of any costs that must result from the event. And I think that is an intolerable position that us men ought to take some steps to deal with. If you have questions, this format doesn't permit questions, but if you have questions, please send me an email, give me a call, let's have dinner or coffee or something. I would be happy to respond to your views about this. And I'm just sorry that we can't do this kind of meeting conveniently in an open forum with COVID restrictions. But I would welcome conversation from any of you on some of these questions if they're pretty deep. Thank you very much.